the property of a deceased is successively applied for the payment of the following claims in order, and they are his funeral expenses and death bed charges. That is the, it will be applied for the again payment of the funeral expenses and death bed charges. Immediately before the death of the deceased, whatever expenses were incurred on him for the maintenance of his health, or along with the funeral expenses, this will also be the charge, and along with the funeral expenses, death bed charges will also be paid out of the gross property of the deceased. After payment of funeral expenses including the death bed charges, whatever property is left out of that, expenses for obtaining probate, letters of administration or succession certificate, means whatever expenses are incurred for obtaining certain requisite documents like letters of administration or succession certificate, that will be a kind of the charge on the property of the deceased. Therefore, whatever is left after funeral and death bed expenses, this expense will be met out. Then third charge on the property according to the Indian Succession Act 1925 is wages due for the service rendered to the deceased within 3 months next preceding his death by any labourer, artisan, domestic servant, etc. It is very much clear that in last days, if anyone was engaged by the deceased for his personal services and he could not pay the charges to the servant, or he did not pay the salaries or wages to the person who was engaged for different purposes, 3 months preceding his death, then this will also be a charge running over the property of the deceased and they will be discharged by making the payment whatever is due to them. For example, if the deceased employed a servant at the rate of rupees 2000, services were rendered to the satisfaction of the deceased, and due to the attending facts and circumstances, before the death he could not pay the wages to the labourer or the servant who was engaged for his personal services, then this and the wages due are for last 3 months, or then this will be a charge and this will be running over the property, and the labourers, artisans, domestic servants, whosoever is unpaid for his services will be paid out of the property left after the 2 payments, funeral and expenditures made for obtaining some important documents or certificates relating to the application or succession of the property of the deceased. Then fourth is other debts of the deceased according to their respective parties, means unpaid debts outstanding in the name of the deceased will be discharged by making the payment in order of priority to the creditors. Fifth claim that will be satisfied out of the property is the legacy, that is if any valid testament is found made by the deceased in his life, then legatees under the testament will be entitled to be satisfied out of the property left after the payment of funeral expenses for obtaining letters of administration or succession certificate, payment to the laborers, artisans, domestic servant, discharge of the debts, whatever thereafter, whatever property amount of the property is left, out of that claim of valid claim of the legatees will be satisfied, or legatees will be given their due amount of the bequest. Again friends, after applying the property for these payments which I have mentioned just, whatever property will be left, that again will be called as residue property, and residue over the residue there will be the claim of the legal years, and therefore the residue will be divided or distributed among the years of the deceased as per rules of the Muslim law. So, residue is the claim of the legal years. Being the claim of the legal years, residue property will go, entire residue will go to the legal years and will be distributed among them according to the rules of Muslim law. So, this is the order of application of the property of a deceased Muslim in order of priority and preference, and this priority and preference basically is based on the fundamental sources of Muslim law. Now, the next an important question that arises, that wasting of the estate after the death of the after the death of the owner, in whom the property immediately wastes, to whom the property ownership passes on. This is the question, this is the legal question that arises. Under the Indian Succession Act 1925, which is based on the English common law, on the death of a Muslim, his estate vests in the executor. For the first time, this power was conferred upon him by the Probate and Administration Act 1881. Under section 4 of the Act, the whole property of the Muhammadan who died after making a will vested in his executors. The property vested in the executor even if no probate has been obtained. As a result of the vesting of the estate in the executor, he has the power to dispose of the property in due course of the administration. The Probate and Administration Act 1881 was replaced by the Indian Succession Act 1925. Under this Act 1925, the estate of a deceased Muslim immediately on death vests in the administrator of the estate. So, very simple that after the death of the owner of a property, according to the Indian Succession Act 1925, the property immediately devolves, the ownership of the property immediately devolves on the administrator or executor, as the case may be, and he will become owner until the entire property is disposed of according to the rules. And being the owner for a limited duration, during this period he will be entitled to dispose of the property. So, under Indian Succession Act 1925, after the death of the owner, ownership immediately goes to the administrator or executor of the property, and he will remain the owner thereof until the entire property is applied for different purposes according to his or her personal laws. And therefore, during the period, this period he will be entitled to dispose of the entire property as a owner. But under Muhammadan law or under the Muslim law, rule is entirely different on this point. According to the Muslim law, the executor or administrator of a deceased Muslim is simply a trustee is simply a trustee with regard to the 2/3 property, and active trustee as to the 1/3 for the purpose of the will. An executor under Muslim law is called as wasi and is recognized under Muslim law, but it did not recognize an administrator. Wasi or executor under Muslim law, because this term executor is recognized under Muslim law, because any person who is appointed as manager or administrator of the property of a deceased through a will by the owner, such person is called as wasi, and word wasi has been derived from the word wasiyat, and therefore wasi or executor is recognized under Muslim law, that there can be a wasi or there can be executor of the property of a deceased. But word administrator has been unknown to the Muslim law. But under Muslim law, wasi or executor is merely a manager of the estate, and no part of the estate of the deceased vested in him as such. As a manager, all that he was entitled to do was to pay the debts and distribute the estate as per the will of the testator. He had no power to sell or mortgage the property of the deceased, not even for the payment of his debts. Therefore, the theory of representation is not known to the Muslim law. Under the provisions of the Muslim law, estates of the deceased Muslim who has died intestate devolves on his heirs at the moment of his death, and devolution is not suspended by reason merely of the debts being due from the deceased. The heirs succeed to the estate as tenant in common in specific shares. As the interest of the each heir is separate and distinct, one of a number of heirs cannot be treated as representing others, but an heir in the possession of the estate of possession of the assets of an estate can be sued by the creditors of the deceased. Each heir is liable for the debts of the deceased to the extent only of his share of the debts proportionate to his share of the estate. Since the estate devolves on the heirs at the moment of the death of the deceased, they are at liberty to divide it at any time after the death of the deceased. The distribution is not liable to be suspended until the payments of the debts. Therefore, any heir may, even before the actual distribution of the estate, transfer his own share, and thereby he can pass a good title to the bona fide transferee for the value, notwithstanding any debts that might be due from the deceased, and a sale of the share of heir in the execution of the decree passes against him at the suit of his creditor amounts to a transfer of his own share. In India, the fundamental principles of Muslim law relating to the administration of the estate revolve round the rules laid down by Justice Mahmood in leading case Jafri Begum versus Amir Muhammad Khan, decided in 1886. The Honorable Court, speaking through Justice Mahmood, in Jafri Begum case laid down following propositions or rules, and they are: Rule 1, devolution of inheritance. In Jafri Begum case, the court laid down a proposition, legal proposition, that when a Muslim dies leaving debts unpaid, his estate devolves immediately on his heirs, and such devolution is not suspended till or contingent upon the payment of the debts. It means that as soon as there is a death of the owner who happens to be the Muslim, leaving debts, unpaid debts along with his property, rule is that immediately after his death, his property will devolve on his legal heirs, and wasting of the property will not remain suspended till the debts are paid, because according to the Muslim law, ownership is one thing and debts running over the ownership or property is other thing. Rule of Muslim law regarding the devolution of the ownership provide that as soon as one owner dies, ownership immediately will vest in the next owners, whosoever will be there. Debt is a charge. So, debt will not stop the vesting of the ownership in the legal years. So, on death of one owner, ownership will go immediately to the others. It is not subject to the payment of debts. Rule second says that a decree for a debt passed against such of heirs as are in possession of estate does not bind the other heirs. Third, if one of the heirs who was out of the possession and who was not a party to the proceeding brings a suit against the decree holder for the recovery of his share of the estate, he must pay his proportionate share of the debts before recovering possession of his share of inheritance. Rule second in Jafri Begum case is important for the learner to understand. Rule second basically goes to establish that decree obtained against one of the heirs cannot be binding on the shares inherited by another heirs. One heir cannot represent his co-heir. That was clarified by the court in Jafri Begum case. In addition to the above guiding rules, the following principle of administration relating to the estate of the deceased Muslim in India may be taken as well established rules relating to the vesting of ownership on the death of a Muslim. They are: the estate of deceased Muslim from the moment of his or death belongs to the heirs according to the law. Second, the proportionate interest of the heirs, if more than one, comes into a separate existence as from the moment of the death, irrespective of any interval that may lapse before the charges on the estate are paid off and residue actually distributed. Third, the devolution is not contingent upon or deferred to any subsequent happening. There is no immediate vesting, there is no intermediate vesting of the estate in anyone, not even the executor or administrator. But under section 211 of the Indian Succession Act 1925, this rule has been modified. And under the Indian Succession Act 1925, contrast to the rule of Muslim law, on the death, ownership vests in the administrator of the estate, meaning thereby that in between the death and distribution of the property, an intermediate owner is created. This is totally contrary to the rules of Muslim law. Muslim law is crystal clear on this point, that there can be no intermediate owner in the name of executor or administrator. Ownership is a right, and this right on the death extinguishes and goes to the other rightful person, that may be the legal heirs of the deceased. If the division precedes payment of the debt, each individual heir is liable only to the extent of of the portion of outstanding debt proportionate to the share he or she has actually received or allocated from the heritage of the means that on the death ownership vests in the legal years of the deceased immediately, and after vesting of the ownership in the legal years can proceed to make the actual division of the property by specifying their respective shares without making the payment of the debt or other charges. In that very event, every individual year will be liable to pay the debt only to the extent of the share he has received out of the property by means of inheritance, not less, not more. So, ladies and gentlemen, this is all about the administration of the estate of a deceased Muslim. In last, I may point out some crystal point of rule that administration here means management and disposal of the property of a deceased according to the rules of Muslim law. Management means application of the property for different purposes in order of priority. The next point important to be kept in the mind regarding the administration of the estate is that on the death of an owner, in him the ownership extinguishes, but at the same time immediately it passes on. It passes out of the deceased to his legal heirs. Means for a single moment the ownership cannot be kept in the state of suspension. Third point is that under Muslim law, after the death of the owner, ownership will directly go to the legal heirs. Legal heirs will by virtue of law will become the legal owner of the property as the deceased was owner thereof. And therefore, in between the death of the owner and actual distribution of the property after payment or application of the property for other purposes, in between nobody can be the legal owner of the property of the deceased, as it happens or is recognized under the Indian Succession Act 1925, that after the death, on the death, whatever property is left, ownership of such property vests in the administrator of the estate, and he will remain the administrator of this estate until there is a total disposal of the property, and until the disposal of the property, being the owner, the administrator has got the power to sell or the mortgage the property like previous owner. This situation is not recognized under Muslim law. Muslim law says clearly that when there is a death of the actual owner, his ownership will go to his legal heirs, and therefore administrator or executor who is in the charge of the property, he will be just like a custodian of the property, will be a mere manager of the property, he will be only a caretaker of the property only for a limited duration, that is until the total disposal of the property. He will be a mere trustee, bare trustee to the extent of 2/3 and active trustee to the extent of 1/3, but he will never be the owner of the property. Since he will never be the owner of the property, therefore he will have no right to pass on ownership to somebody else by means of sale, and in case he does so, the sale will be invalid and legal heirs will be entitled to get the property back from the wedding of the administrator. This point has been made very much clear by the Muslim law. Therefore, Justice Mahmood in Jafri Begum versus Amir Muhammad Khan, by laying down three important legal rules, clarified the entire state of situation dealing or governing the administration of the state of a deceased Muslim. Thank you very much.